If you're a civil contractor in Queensland and you've ever crossed out a subcontractor's invoice because the work was defective, you need to hear this. Short paying a civil works invoice based on perceived defects or backcharges without issuing a valid statutory payment schedule exposes your business to liability for the full claimed amount. Not a portion of it, the full amount. Let's look at why this is the case. Under Queensland's statutory payment regime, your right to set off liquidated damages against a subcontractor depends on strict compliance with the response window under Section 76 of the Building Industry Fairness Act. That window is the earlier of the period prescribed in your construction contract or 15 business days after receiving the claim. Miss that deadline and your ability to dispute the invoice value at that stage is gone. Now, you might be thinking, my subcontract has an offset clause, I'll rely on that. However, here is exactly where the problem lies. Contractual clauses designed to override or limit statutory payment rights, including pay when paid provisions, are void and unenforceable under Section 200 of the Act. Your contract terms will not save you. What is the actual consequence for your business? Failing to respond correctly to a valid payment claim converts an otherwise disputable invoice into a statutory debt recoverable in a court of competent jurisdiction. That means a highly arguable defects claim on your end can become an enforceable judgment debt against you simply because you didn't follow the correct procedure in time. The final takeaway from this is quite straightforward. Every disputed subcontractor invoice must be met with a fully detailed, compliant payment schedule within the statutory deadline. An informal email is not enough. A note scribbled on the invoice is not enough. If you're unsure whether your current process meets the requirements of the BIF Act, obtain independent legal advice specific to your circumstances.